Hello and welcome to The Firm. On the show this week, why is the CCI kicking up a fuss about non-compete clauses? And the US SEC changes its settlement policy to insist on an admission of guilt in some cases. Our top story this week, the Contract Act frowns upon them and the Takeover Code disallows non-compete premiums to selling shareholders. Yet non-compete clauses are standard to most M&A transactions, or at least they were till the Competition Commission of India started kicking up a fuss. You'll be surprised to know that in at least 2 recent deals seeking merger control clearance, CCI has asked the transacting parties to modify their non-compete clauses. Vaishwani Upadhyay finds out why.
In September last year, Hospira Healthcare, the Indian subsidiary of US-based Hospira, decided to buy Indian pharmaceutical company Orchid's API or active pharmaceutical business. The two approached CCI for merger control clearance. CCI cleared the deal on grounds that the combined domestic sales of Hospira and Orchid were negligible and the acquisition is unlikely to have any adverse effect on competition in the domestic market. But the regulator objected to the duration and scope of the non-compete clause in the business transfer agreement. CCI raised the same objection this year in April when US pharmaceutical major Mylan proposed to acquire Indian pharmaceutical company Stride's wholly owned subsidiary Agila Specialties. Most experts don't recall the CCI having scrutinized or object to non-compete clauses before. Neither do CCI's merger control regulations prescribe specific conditions for non-compete clauses.
Non-compete basically means that you are reducing competition at some level. And therefore, if you are looking at combinations, Section 6 clearly says that any combination which is likely to cause appreciable adverse effect on competition will be void. Similarly, if you look at the agreement section, that is Section 3, it also says that any agreement which is likely to cause appreciable adverse effect on competition will be void. So both under the controlling sections of agreements and combinations, there is a clear mandate that anything which is included in the clauses or in the agreements which reduces competition can be looked at by CCI.
That's undoubtedly true. But in these 2 deals, the acquired units were predominantly in the business of export and had little or no domestic sales. What makes it even more curious is that so far CCI has raised objections only in the pharmaceutical sector deals. Lawyers point out that the non-compete clause in Suncoke's purchase of Visa Coke earlier this year faced no resistance from the regulator.
We've seen the orders. There have been non-compete arrangements around combinations in other sectors. We've not seen the Commission make too much of a fuss about the non-compete arrangements there. But yes, clearly it seems to me that the pharmaceutical sector is of particular interest to the Competition Commission of India.
We in fact had done one of the first pharma deals that took place where Mitsui invested in a pharma company. And from that experience I can say it's nothing in particular. But I think pharma sector does become a bit sensitive because it involves a lot of R&D that goes on. And I think the availability of the pharma products to the people in the country. So are there going to be restrictions that actually impose or that create such a problem? A lot of the acquisitions in the pharma sector is also to acquire new APIs that have been developed. So I think that could be a concern, but I don't think it's typical or particular to the pharma sector.
But other lawyers tell me that in some agreements in other sectors, non-compete restrictions of 6 and even 8 years have passed muster. It could be that CCI took issue with these 2 pharma sector deals because of underlying market dynamics, though the regulator's orders offer no explanation. It could also be that CCI is exercising extreme caution given the government's concerns regarding the influx of foreign companies in India's pharma sector. Remember, those very concerns drove the government to propose lower sector-specific threshold as draft legislation. While that is yet pending clearance, CCI seems to have enhanced its vigilance. As a result, in both deals, the transacting parties have had to modify their non-compete agreements. The first restriction CCI imposed was on duration.
The Orchid Hospira deal prohibited Orchid from competing in the transferred business space for 8 years and restricted competition by its promoter K. Raghavendra for 5 years. In its agreement with Strides, Mylan prohibited the company, group companies and promoter Arun Kumar from developing, manufacturing, distributing, marketing or selling any injectable, parenteral, ophthalmic or oncology pharmaceutical products for human use anywhere in the world. The validity of this clause was proposed to be 6 years. But both deals got CCI's approval only after the life of their non-compete clauses was reduced to 4 years.
What's relevant here is that the parties decided what to offer the regulator, and it seems the regulator accepted the modifications that the parties offered to make to their arrangements. So it's not really the Commission deciding that 4 years is good, but it's definitely signaling that 4 years is acceptable to it.
The second objection that CCI raised in both deals was regarding the scope of the non-compete clause. The deals were cleared after the non-compete clauses were modified to cover only existing products. Hospira had prohibited Orchid and its promoter from conducting R&D and testing of 2 active pharmaceutical ingredients. CCI cleared the deal only after the clause was modified to allow Orchid to conduct R&D and testing on new molecules which are currently non-existent worldwide. Mylan's non-compete sought to impose 3 restrictions on Strides, its group companies and promoter. First, a blanket restriction covering injectable products across all therapeutic categories. Second, products in the oncology and ophthalmic categories that Strides did not manufacture. And third, development of new molecules which are presently non-existent. CCI observed that a non-compete clause should cover only those products which the target is either in the process of developing, manufacturing or selling.
The non-competes in these cases, one for very long duration, number one. In one case they actually prohibited R&D. And that in no case would be allowed by any authority. People don't want to restrict research and development of any product, whether it's particularly in the pharma, and I would think it would be anywhere in any sector.
Both cases seem to involve parties that were either export-oriented units or whose business focus was the market outside India. Having said which, in the Commission's analysis, it possibly was a question of, here is somebody who operates as a manufacturer in the market in India, and I am therefore concerned about any restraints on his making a market entry and the scope of that restraint. But you're absolutely right. I'm not sure on a substantive determination, had such a substantive determination been made, would the Commission have really concluded that the non-compete in these 2 cases at least really caused an appreciable adverse effect on competition?
The factors that the Commission has mentioned in the order, that you look at whether the duration or the restrictions on the products or the geographical area in which the products are sold, and the persons on whom you are putting these restrictions, are they reasonable enough? And supposing there is a case where you could prove to the Commission that it will be very reasonable to have a longer duration, maybe they would accept it.
Lawyers say that CCI's position on non-compete is mostly in line with international practice, maybe even lenient. For instance, the European Commission allows non-compete clauses of 3 years duration when the transfer of business includes transfer of goodwill and know-how. In cases where only goodwill is included, the permitted duration is 2 years. The European Commission considers a non-compete clause as unnecessary when the transfer is limited to physical assets or industrial and commercial property rights. In terms of scope, a non-compete clause can cover only those product or service markets where the transferred business is active.
There's no rigorous economic analysis behind that 3-year figure. It dates very much from case law which predates the use by the Commission of economic evidence for assessing cases. So it's very much a legal rather than economic answer. There are exceptional cases where the Commission would take a longer period as acceptable, but that would only be where there was a very long period required to recoup an investment. In most cases, 3 years is applied as the normal length of time. And this has been confirmed in a recent case involving the transfer of a nuclear power business between Areva and Siemens, where the parties had suggested an 11-year period, but the Commission said that 3 years was correct and stuck to their earlier jurisprudence.
Maybe India's competition regulator is simply following global precedent, and it's just a coincidence that the two non-compete clauses that fell foul with CCI happen to be in the pharma sector deals. Maybe non-pharma deals will face the same scrutiny. Or then again, as I suggested before, maybe this is an extension of government's protectionist stance. Maybe we wouldn't have to rely on so many maybes if the regulator clarified its stance on non-competes. In Mumbai, Paiswini Upadhyay.
While the CCI is not the only one up to new stuff. Up next, the US SEC changes its settlement policy to insist on an admission of guilt in some cases.